This is Bloomberg Law with June Grasso from Bloomberg Radio.
Well, I don't want to dwell on things that fall out of the sky, but what about the situation where the fire is caused by something that's utterly freakish? Something a meteorite fell out of the sky, or some crazy person who was hearing voices decided that person was going to go throw a Molotov cocktail in the window of this plant.
But the justices did dwell on some unusual hypotheticals involving meteor strikes, Molotov cocktails, and space trash. You might not guess the issue before the Supreme Court was what information companies have to disclose about past events when warning investors about future risks. Meta's Facebook is trying to get out of a multi-billion-dollar securities fraud lawsuit, accusing it of painting the risk of the unauthorized use of user data as hypothetical in 2016 SEC filings, when in fact the company knew that political consulting firm Cambridge Analytica had already accessed information on 30 million users in 2015. Justice Neil Gorsuch suggested that reasonable investors know about the risk of data breaches at large companies.
I think China probably has all of our FBI files. Data breaches are part of our lives these days.
But some of the liberal justices, particularly Elena Kagan, indicated that investors need to know about misleading statements.
There are a range of ways in which these forward-looking statements can be misleading as to things that have occurred in the past.
Joining me is securities law expert James Park, a professor at UCLA Law School. Jim, tell us about this suit against Facebook.
So this is a lawsuit, class action brought on behalf of investors of Facebook. Now it's Meta, of course. Facebook, as with other public companies, issues periodic disclosures, the Form 10-K on a yearly basis, the 10-Qs. And these typically have a lot of disclosures about risk, which are required by the SEC. And so the idea behind these risk disclosures is that you're warning investors this is the risk of investing in Facebook stock. And one of those risk disclosures basically said that there could be a risk of unauthorized access to user data that could damage Facebook. And the reason why the plaintiffs are saying this is materially misleading is that at the time Facebook made this statement, it knew about a fairly large breach by a political consulting firm called Cambridge Analytica of user data. And so what the plaintiffs are arguing is that you said that unauthorized access could be a risk when you knew there was a very significant unauthorized access at the time you issued that risk disclosure. That's essentially what the securities class action is dependent on.
So let's talk about the argument. And there were a lot of strange hypotheticals thrown around. What were the concerns of the justices?
I think one concern is that companies issue a lot of risk disclosures about many different things. And, one of the concerns that the justices are grappling with is that if we say there's liability in this case, does that mean that for almost every type of risk disclosure that is being issued, that a lawsuit could come up if you phrase things in the wrong way, if, there's something that happens relating to that risk. And so there may be too much liability there. And, the effect of that may be that companies will just issue very vague risk disclosures that don't say anything. They may not issue risk disclosures at all, right? If I make you liable for a misleading risk disclosure, then maybe I won't issue that risk disclosure at all in the future. I think that's a concern. And I think they're also just concerned that the rule seems to be unclear here, and it's tough for companies to navigate, what you have to disclose and when you have to disclose it. And, there's a concern here that we don't want to create a general duty to update everything in these disclosures because there's so much in any SEC disclosure that it may be impossible to constantly update every single aspect of it.
Is the question how much to disclose of the past in the present? If you don't think the past is going to affect the future, what's the exact issue?
I think what Facebook would say is these are primarily forward-looking statements. They are predictions. And so they're not really meant to guarantee every single thing about past events. I think that they're saying that we're making no guarantee that there has been no unauthorized access to user accounts. And in fact, I think they would say, of course, there have been some abuses of Facebook privacy policies, and everyone would know that at the time the risk disclosure had been made. And I think Facebook is making a fairly subtle argument here, which is to say that it's true that we knew that there was an unauthorized access by Cambridge Analytica. What we didn't know is that it would affect our business so much. We had no way of knowing that. And essentially, we have no way of predicting the future. We just didn't know that there was an event that would eventually cause significant economic damage to Facebook. We made no implicit representation about the past in this particular disclosure. It's more of a forward-looking disclosure in this case.
A hypothetical from Justice Kagan. A lot of the justices kept coming back to it. A company discloses a risk of fire, but doesn't disclose that there had recently been a fire that destroyed 50% of the plant.
Yes, that's a great hypothetical. And I think it pushes back upon sort of Facebook's statement that these statements do not make implicit representations about past events, because implicit in the risk of a fire in a building is that the building is still there. I think that's one implicit recognition. And I think there's also a recognition that there's not a known high risk of the building burning down. And I think that investors would want to know if there's a very, very high risk that the building is so unsafe that we know it's very likely that it would burn down. What she's arguing here is that, we should be requiring companies, when they make these risk disclosures, to also speak completely and disclose risks that they know about, that they can calculate with some reasonable assurance. And that's where Justice Kagan may come out at the end of the day.
Justice Brett Kavanaugh asked, why can't the SEC just write a regulation?
I mean, why does the judiciary have to walk the plank on this and answer that question when the SEC could do it with all the uncertainty and all the hypotheticals that have arisen, which in turn, at least as I see it, just speaking for myself, raises a lot of questions for companies about what they have to disclose and what they don't.
And the Chief Justice and Justice Amy Coney Barrett seem to agree with that. I mean, why can't the SEC write a regulation?
They could, but it's difficult to write good regulations. And I think that the more general the regulation is, the easier it is for the SEC. That's one reason the SEC is not adding more specificity. It's also easier, though, I think, for public companies, right? The more specific you write the regulations, then, the company is going to have to dig out all of this specific information, and that could be overly burdensome. And so sometimes corporations want fairly vague disclosure requirements that they have some discretion to comply with. And that's the whole idea behind principles-based regulation, which a lot of, what you might think of as conservatives have advocated for SEC regulation. But I think Justice Kavanaugh has a good point, which is that, if you are leaving this to lawsuits to decide, then, courts, which are not experts in these matters, have to make these very difficult, complicated determinations of what should be disclosed. It also gives a sense of regulation by enforcement, where lawsuits are being used to regulate companies after the fact. And that's a running theme about both lawsuits by private litigants as well as lawsuits by the Securities and Exchange Commission. So he asked a very good question, but I think that there are some pressures that make it difficult for the SEC to specify completely what the disclosures should look like. And so what we have is a very imperfect system where, these issues get fleshed out in lawsuits, and often the lawsuits are settled, so we never even actually resolve what was required. So, the requirements of disclosure for public companies, there's not clear guidance. It's a lot of discretion. It's a lot of judgment that is required in order to craft good disclosures. And I think there's, some resentment by public corporations that you have private enforcers who have a monetary incentive to sue whenever they find something wrong in a company's disclosures. And, you have to pay a lot of money sometimes to settle these lawsuits because you don't want to risk them going to trial. Now, one point I would add, though, is that in addition to this private class action, the SEC brought a case against Facebook for, I believe, essentially the same disclosure. And they alleged that they were materially misleading. And Facebook actually settled that case for $100 million. So the SEC also has been asserting and pushing this particular theory as well.
Do you have any feel from the oral arguments about how they might rule?
I think it'll be a very fact-specific decision. I think that the court understands that this is a really, really hard issue, and the Supreme Court is not qualified to write very detailed disclosure rules. And so I think they will try to limit the case to its facts. It's a tough one. It's really tough to predict which way they're going to go. I suspect maybe a majority will side with Facebook, that this is a case where, sure, they knew there was a breach, but they didn't know it would impact the company's business as much as it did, and therefore the risk disclosure was not materially misleading. Now, it's possible, though, some of the justices will buy the plaintiff's response. Basically, their response is that, okay, you must have known that, given the size of the breach, that it was going to really affect your reputation at the time you made that statement, and therefore the risk disclosure was misleading. What you should have done when you wrote the disclosure was acknowledge, hey, we have this very, very unprecedented, significant breach of millions and millions of users' data. That's the disclosure you should have written. But I think it's going to be a close one, and I think there could be some disagreement. But what I am confident of is it's going to be a fairly fact-specific decision.
Did you see a split between the conservatives and the liberals?
Somewhat, although some of the conservatives, I wasn't quite sure which way they were going. Justice Thomas starts out and asks some questions that I thought were leaning a little bit towards the plaintiffs. Justice Kavanaugh's question is more just about why are we even deciding this in the first place? I do think the liberal justices probably seem to be mostly sympathetic to the question. And, Justice Alito has thought a lot about these issues. He decided a few cases when he was on the Third Circuit. I tend to believe Alito, based on the Burlington Coat Factory's decision, would be less inclined to say that those disclosures were misleading, but I could be wrong on that. It's hard for me to say, but I think you could see some coalescing that might break down under conservative and liberal sort of lines.
Thanks for joining me, Jim. That's Professor James Park of UCLA Law School. There's been a lot of speculation that in a second term, Donald Trump could create a high court with a Trump-appointed conservative majority that could serve for decades. After all, Trump appointed 3 Supreme Court justices in his first term who've made up a supermajority that moved the court far to the right. But it was the deaths of Justices Antonin Scalia and Ruth Bader Ginsburg and the retirement of Justice Anthony Kennedy that opened those vacancies. Of course, with the help of then Senate Majority Leader Mitch McConnell, who blocked President Barack Obama's nominee, Merrick Garland, and pushed Amy Coney Barrett's confirmation through in record time. It would take 2 justices leaving the bench for Trump to be able to claim having nominated a majority of justices on the court, matching the record of President Dwight D. Eisenhower. Joining me is constitutional law expert David Super, a professor at Georgetown Law. David, there's a lot of speculation that 1 or 2 of the oldest justices, the super conservatives actually, 76-year-old Clarence Thomas and 74-year-old Samuel Alito, could retire and give Trump a chance to put younger conservatives on the court. Do you think that's likely?
I'm not sure that it is. They both show every sign of enjoying their jobs. Progressives don't like how they're doing their jobs, but their opinions remain sharp. When they choose to speak from the bench, they make sense. So I can certainly imagine them feeling like they want to keep doing this.
Well, Thomas, the New York Times reported that he once told a former clerk that he intended to stay on the bench until 2034. The liberals made my life miserable for 43 years, and I'm going to make their lives miserable for 43 years. So we have some time yet before he considers retirement, I suppose. On the liberal side, there have also been renewed calls for 70-year-old Justice Sonia Sotomayor to retire before January so President Biden and the Democratic-controlled Senate can quickly confirm a successor. I don't know about quickly, but that whole scenario seems unlikely to me.
Yeah, I can't imagine that she would do that, and I think it would be a foolish move to try. There was talk about Thurgood Marshall retiring after Jimmy Carter lost for re-election, and I think cooler heads prevailed there and recognized that that couldn't be done in a snap. Now, I can't imagine that Senator Manchin or Senator Sinema would be okay with this sort of a process at this point, and without them, you can't do anything.
As far as future judicial appointments, there have been reports that Trump complained about his first-term appointees being too independent and not being loyal enough to him. And, reportedly has fallen out with the Federalist Society, which basically chose his judicial appointments during his first term. So what do you expect from Trump as far as future judicial appointments?
I think he's not especially focused personally on the courts. He's not a lawyer. He's never shown a lot of interest in it. So my suspicion is that he will go back to the Federalist Society, perhaps not give them as celebrated and formal a role in the process, but that we will basically be getting more FedSoc judges.
And more ideologues? It seems like even the judges that he did appoint were ideologues more than respected jurists.
He appointed a range. Some of his appointments are splendid judges. Some of them are skilled ideologues, and some of them are rather lost. I'm guessing the new round will include some in each of those piles.
Now, the Biden administration has taken positions in certain cases before the Supreme Court, and we can anticipate that the Trump administration has opposing views and will want to back out of those positions. How often does it happen that a new administration changes positions in cases before the court?
It's become more and more frequent over time. Once upon a time, it was considered shocking enough that the Supreme Court would appoint a lawyer to argue the case as friend of the court, representing the position of the prior administration. These days, there's less of that. I think it is understood by the justices that this is what happens in a society where views on law have become very polarized.
Actually, in 2018, Justice Sotomayor seemed to criticize Trump's Solicitor General Noel Francisco for urging the court to overturn a precedent that allowed public sector unions to collect fees from non-union members when the Obama administration had argued in a prior case that it should be upheld.
This is such a radical new position on your part.
I don't think...
Mr. General, by the way, how many times this term already have you flipped positions from prior administrations?
Your Honor, I believe...
This may be... How many?
Your Honor, I think that we have revised the position in so far 3 cases.
But the court ended up siding with the Trump administration and overturning the 40-year-old precedent. Transgender rights is one area where it seems likely that a Trump administration will want to change positions. The Biden administration is fighting a Tennessee law that bans medical treatments for adolescents with gender dysphoria. Arguments are scheduled for December 4th, well before Inauguration Day. What might happen in that case?
Well, the Trump administration has a couple of options. One is that they can ask the court to reopen it to allow supplemental briefing. Whether the court would be inclined to slow itself down to allow that is debatable. Second, they can simply declare that their allegiance are on the other side and rely on the briefs that were opposing what the Biden administration advocated. They can also express the intent to take executive action to reverse federal regulations, but that can't be done instantly. The court could decide the case and let them take their own action through due course, or the court could suspend the case to give them time to act, or the court could decide not to issue a ruling because it expects the issue to go away.
The federal government already argued a case over ghost guns to keep regulations for ghost guns on the books. So that's already been fully briefed and argued. Now, it's anticipated that the Trump administration might oppose those regulations. What happens there? Do they just pull the regulations?
Well, you can't just pull the regulation. The Administrative Procedure Act and the Supreme Court have been very clear that you have to go through the same procedure to remove regulations that you did to create them. So it would take a certain amount of time, probably a year even if they move very quickly, to get rid of those regulations. This is a case where the conservative legal agenda has a somewhat ironic impact in that a year ago, the administration changing its views on how the statute should be interpreted would be entitled to considerable weight. But today, because the Supreme Court got rid of Chevron, the administration is not entitled to any deference anyway, so one can well imagine the court saying, we really don't care if you've changed your position.
Really? Just ignoring the Trump administration?
Well, we're very early in the post-Chevron world. There always was deference. The administration's position mattered a great deal, but the court went at great length last spring to tell us that Congress did not intend administration views to get any special weight in interpreting laws, and on that basis, one could well imagine the court simply going ahead and deciding the case and saying if the administration wants to go through the procedures to remove the regulations, they're free to do so. But what the administration might or might not try to do or succeed in doing in the future doesn't stop the court from deciding the case in front of it.
And the court's conservatives have been basically reining in federal agencies. Do you think that we'll still see that kind of aggressive attack on regulatory agencies by the court in a Trump administration, which may be using agencies to affect some of these broad changes?
I think different justices will have a different view. Chief Justice Roberts has very little patience for sloppy, incompetent agency work, whichever ideology the agency has. And when presented with dishonest or incompetent agency actions in the first Trump administration, did not hesitate to strike it down. So I would expect he would be continued inclined to look closely at agencies and whether they're dotting their I's and crossing their T's. Some of the other justices probably will feel that a lower level of scrutiny should be applied to deregulatory actions than was applied to regulatory actions.
Some disputes coming up involve the EPA, whether fights over certain clean air regulations can be heard by circuit courts. How might the Trump administration handle that case?
That's harder to know because that's an issue of process that has implications that go far beyond the current or next administrations. So one could imagine that the Trump administration, although its view on the ultimate merits may be different, might not feel that that's a high priority to expend its credibility with the court by switching positions and may see some benefit to staying out of it or not disrupting what the Biden administration did.
Have you heard any rumors about who might be the Solicitor General?
I have not.
I have not either, and I can't believe that because I've heard rumors about many other high-level positions that will have to be filled.
I think that the new administration is going to want someone competent and credible, and so what you hear, or at least what I hear about various other positions, are people who may not be especially skilled or especially respected, but are very close with Trump circles and with the former president. I would expect the new Solicitor General would be an extremely conservative lawyer, but not necessarily someone who Trump knows.
There's going to be a lot to watch at the Supreme Court next year. It's always a pleasure to talk to you, David. That's Professor David Super of Georgetown Law. Coming up next on the Bloomberg Law Show, how ballot measures will change access to abortion in 7 states. I'm June Grasso, and this is Bloomberg.
We've done something on abortion that nobody thought was possible, and I give those 3 brilliant, if you think about it, and it's 6, but the 3 that we put in, but 6 brilliant justices of the United States Supreme Court a tremendous hand for their intelligence, but also for their courage.
Donald Trump has taken credit for the Supreme Court ending the constitutional right to abortion in 2022, which cleared the way for 21 states to ban or restrict access to abortion. But in the last 2 years, nearly a third of the states have put abortion rights on the ballot. Constitutional amendments to protect or expand abortion rights passed in 7 of the 10 states where they appeared on the 2024 ballot, including in 4 states that voted for Trump. Joining me is healthcare attorney Harry Nelson, a partner at Leach Tishman Nelson Hardiman. Harry, abortion rights ballot measures passed in 4 states that voted for Trump: Arizona, Missouri, Montana, and Nevada. How do you reconcile that, considering his having bragged about getting Roe v. Wade reversed?
It's clear that abortion rights and reproductive health access have a majority of support in pretty much every corner of America, except that the issue is not the driver in this election that it was in the 2022 midterms, for example, and that clearly voters who supported Trump were, willing to see his abortion policy and politics as distinct from the broader anti-abortion movement. So it does seem like abortion was not the powerful issue that it was in the previous election cycles since the repeal of Roe v. Wade, even though it still clearly garnered significant support in most of the places where it was before the voters.
In Missouri, nearly 52% of voters cleared the way to undo one of the nation's strictest abortion laws, while nearly 59% voted for Trump.
Yeah, Missouri had a near total ban on abortion, and so this is a significant decision. One of the things we can certainly take away is there was a huge gender gap in this election, but many men who sort of propelled Trump to victory in the presidential race also supported abortion rights and voted. And so I don't find that result surprising. It's clear that, President Trump opened up some space between himself and the anti-abortion movement. And it's also apparent that the driving factors that propelled his victory had less to do with reproductive rights than other issues when you see this kind of a split result.
Now, Arizona, which had the longest ballot in state history, it took up like 2 pages. And apparently, momentum was gained there because a state Supreme Court ruling in April found that the state could enforce this strict abortion ban from 1864.
Yeah, the court decision earlier in Arizona obviously shocked voters there. And so, Proposition 139 protects the right to abortion in the state constitution itself, which is really significant, up to the point of fetal viability, which replaces and gives a longer period than the 15-week ban that had been there. So it's a significant move on the part of Arizona. And again, not that surprising. In general, the victories that the anti-abortion movement has had have come from courts for the most part.
Abortion rights measures also passed in 3 states that voted for Harris: Colorado, Maryland, and New York. So Colorado's measure, besides enshrining access to abortion, also undoes an earlier amendment that barred using state and local government funding for abortion. So what does that mean?
So that's significant in that it really opens up not just access itself, but funding, reimbursement for providers to keep professionals who are working in this area of facilities open and ensuring access to the state portion of Medicaid funds. So one of the issues that we may see come up now that it looks like we're going to have Republican control over both parts of Congress and the presidency is potentially more restrictions on federal funding. So Colorado seems to be the first state to ensure that there's going to be state funding, and we're talking here mostly Medicaid funding and other, facilities working on special grant programs in this area. So I think that's a harbinger of a trend that we're likely to see in other states, particularly as we see a likelihood of more federal restriction.
New York's measure was a little different. It didn't even mention the word abortion.
In New York, it was a proposal that prohibited discrimination based on pregnancy outcomes. So it was not a direct abortion rights. New York already has an abortion rights law, but it's interesting. New York kind of went a step further in a different direction, right? Colorado went further on public funding, but New York went further on identifying a possible risk of discrimination that an employer could, for example, make an adverse decision based on, pregnancy outcome. So it sort of identified and broadened the scope of protected rights beyond the right to the abortion itself, which was already in place.
In Maryland, abortion is already legal until viability. But explain the importance of putting abortion rights into the Constitution.
In Maryland, it was a constitutional amendment, which is significant because it establishes a much more permanent right than a mere ballot measure. Obviously, when something is placed into the Constitution itself, it establishes it as a more fundamental right, and it forces courts to sort of put a primacy on that right. So recognizing a right to abortion as part of a broader right to privacy really sets a direction in state policy that's going to reverberate much further in the future, and not only in court review, but with regard to future ballot measures. It sort of just sets a higher order of magnitude of priority on the question, and so it's obviously it's a better place to be, right? We see some states that have moved to pass ballot initiatives because those are the quickest way to get things done, just to present a measure to the voters where state law allows, but actually amending the state constitution really is a fundamental way to give more security to the principle of a constitutional right to reproductive freedom.
Just because they passed these amendments, that doesn't mean that the abortion bans in these states are suddenly off the books. It requires some court action, doesn't it?
Like we've seen with abortion going back for the last 50 years, a lot of times these laws stay on the books, and we're actually going to need test cases to come up and have courts formally rule, on the status of some of these old laws. So there are a couple of places where these laws are going to change things, but we're still going to have to see cases filed, a little bit of anxiety and stress for the providers and the patients who are in those cases. But for better or worse, that's just the process that we're going to see go forward here.
I mean, can we assume that judges are going to follow the amendments and not put their own sort of stamp on it?
I think the guarantee of abortion rights is something that should give security here. I do think that while we do see some opportunism from judges who feel strongly on the anti-abortion side, they can't do very much given the appeal structure, and obviously appellate courts put the issue before multiple judges and hopefully ensure that the law actually gets followed. So I don't think anyone should worry that these laws are not going to actually be, implemented and enforced. It's just we're going to have to go through a process to actually make that happen.
And abortion amendments did not pass in Florida, Nebraska, and South Dakota. Florida, what's unusual is that most voters supported the Florida measure, 57%, but it fell short of the 60% required. So what's happening is a minority of voters are able to keep the abortion ban in place.
Yeah, that's a very surprising result. Obviously it came very close. It's good news that 57% of the voters support abortion rights, but obviously this 60% threshold that Florida law requires to amend the Constitution was a barrier, and so we're stuck with the current Florida abortion ban, which is a 6-week abortion ban very early, and that's a problem. So Florida has more work to do, and we're going to see the fight continue. The fact that it was 57%, that it came so close, makes me suspect that we're going to see this issue return on the ballot in midterms, an election cycle that is likely to draw out a different voting pool in midterms. That's pretty close. So while it is a victory that the anti-abortion activists can claim, it's a pretty narrow victory, and I don't think it's one that will hold up.
And also the governor there, Ron DeSantis, pulled out all the stops against the amendment, having election police go to voters' front doors to question them about signing a petition to add the abortion referendum. He had a website. I mean, he really went out of his way to try to get that defeated.
Yeah, it's a little bit surprising that DeSantis went to such extreme measures, but, who knows what his plan is. He came away from the presidential election defeated, and obviously someone is advising him that this is a winning place for him to be tough. I think the fact that it still got 57% of voter support should hopefully raise questions and give him pause, but very surprising that he made such a stand on this issue.
In Nevada, it was the first time in state history that competing initiatives appeared on the same ballot. And I'm wondering if that had anything to do with the defeat of the abortion measure.
I think there's an issue of confusing the voters with competing ballot measures here, right? The one that was approved was the one that enshrines the current 12-week ban with an exception for rape, for incest, and for the life of the mother. But the broader measure that would have added the right to abortion access to the state constitution failed. I do think there was an element of voters going for a more modest choice when presented with two alternatives. And I also think that here, too, this election drove out a different voter base than we're likely to see in the midterm elections. And I think that this is not the last word in Nebraska, so that while this is a setback, certainly for the reproductive health access advocates, it was an unfortunate kind of competition and one that has slowed things down in Nebraska.
What kind of an impact can Trump as president have on abortion rights in the country?
Well, so we've heard a lot about whether there's going to be some kind of national position created to coordinate abortion restriction. Obviously, we have enormous amounts of federal healthcare dollars at stake through not only, Medicare, Medicaid, but through all the various federal funding programs. So I think there is room, if Trump is inclined to be, supportive of anti-abortion activists. Those are certainly two major ways. The thing I'm watching most closely is that we avoided a problem with the FDA pill that was challenged, mifepristone, the abortion pill that activists in Texas got a federal judge to ban, and we saw a whole drama there that the Supreme Court put to rest. But now the biggest question to me is whether, Trump or Trump's people are going to try to make the FDA a site of more problems for telemedicine abortion. We already know telemedicine abortion with mifepristone is now something like 60% or more of all abortion, which has really transformed it to a much more private matter, where women don't have to come to clinics to have a procedure. They can choose the time and place where they take the medication and have much more privacy in the process itself. So to me, the sort of scariest possibility is the politicization of the FDA. It's going to be very interesting to see what happens with health policy under Trump. When he was elected in 2016, I co-authored a book making a lot of predictions, and I learned my lesson. It's always dangerous to get ahead of what's going to happen here, but I'm definitely watching with bated breath to see how much the FDA gets politicized, or hopefully whether, we'll allow the experts who are policing the safety of our drugs and other medical devices and supplies do their work without interruption. So that remains to be seen.
Thanks, Harry. That's Harry Nelson of Leach Tishman, Hardiman Nelson. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.